1833. In 2008, we had an incident with that. Yeah, so today that one.
Mr. Woodyard, who do you have again?
Judge, I'm here representing Mr. Marcus Inman. I was a little unclear from the Register of Actions. It says bond 5,000. I don't know if that's a personal or a cash. I couldn't tell looking at it.
Mr. Glenn, how can I help you?
Yes, Sean, I'm on LaShawn Davis.
I have an APA here for my domestic violence case.
No.
Johnson, you ready on hurt?
I'm ready, Your Honor.
I don't think we have hurt yet. I think we have Bridges here. I'm sorry.
Oh, okay. All right.
I heard in front of the screen. We can put him in front of the screen.
Yes, we can. Can I have hurt, please?
Absolutely.
Thank you. Okay, Ms. Ripley, we're about to do hurt.
Okay.
Calling case number 2305-556-201, people of the state of Michigan versus Clarence Hurt. Defendant is charged in count 1, criminal sexual conduct, assault with intent to commit sexual penetration. Defendant has a offender sex offense notice.
Appearances for the record, please.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
Good morning, Your Honor. May it please the court, Dwayne Johnson, P41842, on behalf of Mr. Clarence Hurt, who is present, Your Honor.
Tell us your name, Mr. Hurt. Can't hear you, sir. Well, he's there, and I read his lips. He said Clarence Hurt. What's your pleasure, Mr. Johnson?
Well, Your Honor, we're going to want a preliminary exam on this matter, and I also would like to address the bond if possible.
Court will continue to plead not guilty and set this matter for preliminary examination. Now is March 15th at 1:30.
March 15th. That works. Your Honor, I do need the Kids Talk video, hopefully prior to that.
Yes, Judge, I did send an order signed by myself and defense to your clerk, I believe, yesterday. So if the court would be able to sign that and send back a signed copy, I can send it over to defense today.
Okay, sounds like a plan.
Okay.
March 15th at 1:30. You want to address bond?
Yes, Your Honor. Right now, my client's bond is $150,000, I think, cash surety, and it's too high for him right now. He did have a job that he had been working for a year. He does have young children that he takes care of, and my client claims he is innocent of these charges that have been charged against him. Your Honor, with him not having any kind of history of this type of charge or any assault of charges, the only thing I think he's on probation for CCW. But outside of that, he doesn't have anything assaultive on his record. So we'd ask that Your Honor would consider reducing the bond to something that would allow him to get out and work and take care of his children, Your Honor.
Your Honor, I think that there's probably a bond redetermination on this already. If we don't have a DSU, I would request a DSU, and so that we can get more of a clear picture as to bond and any kind of bond issues in this case.
So Ms. Ripley makes a valid point. Didn't this go to a bond redetermination hearing already?
I wasn't on the case, Your Honor, when that happened. I think there was a review. I'm not exactly sure what happened at that point.
So I'm pretty sure what happened. The bond was set at the amount that it's set at now. What has changed from then till now?
Well, I just think it's excessive for his history, and also the fact that he's innocent of what he's been charged with. He doesn't have any assaultive history. He's working. He has young children that he provides for, and so we would ask that. And this alleged incident happened in the home that he lives in, so we'd ask that, Your Honor, that you would consider reducing the bond to something that he can handle. Even a personal bond with a tether would be fine with us, Your Honor. He doesn't have any history of flight risk or not showing up for court hearings or anything like that, as far as I know.
Let me see that. Anything else, Ms. Ripley?
No, Your Honor, we would request a DSU.
It's gonna be late, late tonight. Oh, you want to continue? We're gonna get home then.
All right, the court, understanding that this matter is just allegations at this time, they're very serious and disturbing allegations. I'm not inclined to reduce the bond at this time. I'll refer to pretrial services for bond recommendation.
All right, thank you, Your Honor.
Thank you, Judge.
Be in contact, Mr. Hurt. Did you say 1:30 on March 15th, Your Honor?
Yes, sir.
Okay, all right, thank you.
Mr. Kleinfeld, what can I do for you?
I think I had on the docket PCC for Craig Harris. Although we already have an exam date, so I'm not sure.
There's
That
the
was
PCC. I set the exam date, sir.
And we're still
did-
waiting, just so Mr. Kleinfeld knows, we're still waiting for the jail to sign on. And I do need to change, obviously, I'm still waiting for discovery and everything. Maybe while we're waiting for the jail, Mr. Kleinfeld and I can go into a breakout room very quickly.
Bridges. Yeah, I think we're ready on Bridges.
Calling case number 2305-564601. People of the state of Michigan versus Rayvon Bridges. Defendant is charged in count 1, criminal sexual conduct, first degree.
Appearances for the record, please.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
Morning, Judge, to you and your staff, Robert Burton Harris, P81843, on behalf of Mr. Rayvon Bridges, who I believe is present on Zoom from the Wayne County Jail.
Tell me your name, Mr. Bridges.
Good morning, Your Honor.
What's your name, sir?
Ron Bridges.
All right, what's your pleasure, counsel?
Thank you, Judge. So today is the day set for the PCC. We'd like to keep the preliminary examination date scheduled for March 7th, I believe. I would like to address bond. So if that changes things as far as the date is concerned, we will be willing to move that date. But because of the issues that relate to bond, I would like to have this exam sooner rather than later, if at all possible.
So I'm not exactly sure why they do that at arraignments, other than it's by statute or whatever the case may be. What the probable cause conference date is given, as well as the exam date is given, but that exam date is fictitious as far as I'm concerned, because I set the exam date, and I have no more room on March 7th.
Well, I guess that it's even more imperative then, I think, that we should maybe address bond. Obviously, it's whatever Your Honor prefers, but if you want to, we can address bond, and that may kind of help us out on the exam date.
Yeah, I can do March 13th at 10 o'clock.
That's a good day for the people.
I'll make that work, Judge.
Okay, that's the bond.
Judge, I don't know if you had a chance to review it. I did file and submit a bond motion for Mr. Bridges yesterday. I tried to hand deliver a copy to sister counsel, but their office is closed, so I emailed her. My understanding from conversation is that she did receive that. So in essence, Judge. I'm asking for a affordable bond, Judge, in this case. Mr. Bridges has a couple different diagnoses that he receives SSI for. That was not included in the order just because I just found that out. Importantly, he's right now on 23-hour lockdown with 1 hour out a day, and that's if he gets that 1 hour. And my understanding, speaking to the jail staff, is that that's due to their COVID policies. Be that as it may, because of his specific diagnosis, no doctor would say that it's okay to keep this particular person in custody for 23 hours a day. I'm concerned for his safety. I've spoken to him a couple of times in person, and he's not doing well, Judge, mainly because of the 23-hour lockdown, but because he's just in jail. But furthermore, and most importantly in this case, Judge, I have interviewed 11 witnesses. All of these witnesses were at the location where the supposed sexual conduct happened. Every single one of them is ready to testify at the exam and or provide an affidavit saying that they had direct view of not only the complainant, but my client in this case, which was, and he was only at the house for maybe an hour. So the idea that the prosecution, I thought your lips moving, Judge. I didn't. Did you say something?
To my clerk.
So the idea that the prosecution would be able to establish the elements of the crime, not even the elements, but even be able to show probable cause at an exam is almost non-existent in this case, Judge. Like I said, I've talked to these witnesses. No detective has interviewed any of these witnesses. I've actually even spoken to another individual who's not even related to the family, and they haven't been contacted about any of these allegations. So with that, Judge, I know that Sister Counsel was concerned that was already a bond review in this matter. I spoke to the attorney that handled that bond review yesterday, and he just frankly didn't have all of the information about the case and even specifically about Mr. Bridges. So I'm asking, Your Honor, and I know generally you like to, or the court usually will order a DSU report if a bond termination or redetermination hearing has been held. In this case, Judge, I'm asking for an exception to that because of the nature of Mr. Bridges' diagnoses and also because of the information that I've given you and also put into the bond motion. I also think that his mother was on earlier and she was told that she had to get on YouTube, but she's also willing to get on and answer whatever questions Your Honor has. I have an address for him if he was put on tether and put on house arrest or anything like that. And that address doesn't have any children or anything like that as well.
Yes, Your Honor, the people are concerned for the safety of the public in this case, especially for the young complainants here. They are biological cousins. That does cause us a lot of concern. And the fact that this happened, this is initiated at a young child's birthday party, as they were all together, and then finally ended at the house at which I believe the defendant resides. They are all family. They do all know each other, and so I'm very concerned that there would be any potential contact with the complainant or her family personally. I know that there are obviously different sides to every story. I know that initially that the defendant's mother, I believe, didn't believe it, but the complainant was kids talked. She did make she did disclose sexual contact. Your Honor, given the nature of the charges, we would request a DSU. We understand that defense's position, but we would request a DSU in this case.
So my understanding is that you have a complaining witness who will testify to these sexual acts as well as her brother.
No, just the complainant. Her brother is not.
Your investigator's report says that she stated it ended when her brother observed the incident and hit the defendant to make him stop.
Is this on Rayvon Bridges?
Yes. Bottom of the second page of the investigator report.
Oh,
That's talking about a
yeah.
different.
Okay, yeah, I understand where you're at. Sorry, Your Honor, I just signed a couple of cases. No, I would just have the complainant testify.
And again, Judge, all of the witnesses that I have that are ready and prepared to testify were at the house and also at the birthday that Sister Counsel alluded to. Every single one of them will testify that they had direct vision of the complainant and also of my client, that my client was not even there for that long, and that at no point were any of these two individuals together. And as far as the allegations, I put in the bond motion where I think this stems from, and it involved the mother. I actually cited a case that she made similar allegations, but again, I guess recanted in another unrelated case to my client. So there are some issues that I don't want to really go into about the family and why I think these allegations were made that I guess we'll come out and examine if we need to. But as far as what the prosecution is alleging, they haven't even addressed any of the concerns that I've raised, and specifically about all of these witnesses who would testify directly that there was absolutely no possibility that these allegations are true in any kind of way. And if Your Honor is concerned for safety or anything like that, he can be on house arrest, Judge, until we have the exam. I just really need to. I would just like to impress upon the court the need for him to be out of custody because he's just not doing well at all. And I don't know exactly how his condition will improve and or deteriorate before the exam if he's held in custody.
He's 20 years old. What is he doing now with his life?
He's 20 years old, Judge. He does work. He works for his sister's boyfriend, Mr. Eugene Johnson. They do like home construction. So that's primarily what he's been doing. I can provide documentation. I can get Mr. Jones on the call to tell you more about his job. But that's primarily what he does. He goes to work and he goes and stays with his girlfriend. That's what he does.
How far did he go in school?
I believe that he graduated, Judge, but I'm not out. It's in my notes. Just give me 1 second.
How far did you go in school? Not understanding what's going on with the county jail. I can't hear him. Nod your head if you graduated from high school.
I ain't graduated high school just yet, but I'm still going to 10. I'm in 12th grade.
And I think this has to do with his IEP, Judge.
People, are you going to be proffering any DNA evidence or anything?
I don't have any at this time, Your Honor. I will follow up if there were any labs or medical reports in this case.
Because this allegedly took place on a certain day. On that date, did she go to the hospital and do a rape kit or anything?
I think that she did go to the hospital, Your Honor, and I don't have the medical reports yet.
Mr. Bergen Harris, you said he's not doing well in jail. What do you mean by that?
I mean that his mental health. I'm not a doctor, obviously, Judge. I do have some familiarity with autism. A very close friend, family friend of mine, a family member of mine has autism. So he presents as somebody who's on the spectrum, but he's just it's constant. I don't want to say too much just because other people from the jail can hear, and I think that puts them at danger. But all of if you had any type of young person who was in serious mental distress and how that would manifest itself outside of some type of specific attempt to self-harm, Mr. Bridges presents that and manifests those symptoms. So constantly upset, not really able to even communicate because he's so emotionally distraught. I don't have any competency concerns or anything like that, but it's very difficult to even communicate with him because this is having such an adverse effect on his mental health.
So you say that there was another case in which this same complaining witness recanted?
I believe it was a recantation. That was based on what I've spoken with the family who were familiar with that case. And I think that was a recantation. She's from looking at the ROA at that case, she certainly didn't come to court for the preliminary examination, and that she was the one of the complainants for. And also the individual that was the complainant in that case is actually a person that she's with right now. So that's kind of the only real details or the facts that I can relate to the court, as to what I know about it. So I can't say definitively if there was a recantation, but I certainly know that there was the claims were unfounded, and she didn't come to court after she made the claims. And she lived with the person who supposedly had harmed her and her children.
And I think the person he's referring to that recanted would be, or potentially had recanted, would be the complainant's mother, not my complainant, the child.
Right, and so in my understanding is that first case that
he sexually assaulted the mother.
One more time, Judge, I didn't hear the question.
The allegation is that he allegedly assaulted the mother.
And my understanding was that not my client, this is another individual, had assaulted the mother and the complainant in my case of the court, and she lives with that individual.
I see. So you're saying that false allegations were made against someone else at some other point in time, that was the mother as well as the complainant in this case?
That's correct. And that's addition to other false allegations that I have details about that I just didn't want to muddy the record up for today's purposes on.
And where is he going to live?
I have the specific address if you want me to put it in the chat, or if you want me to just to give it to you.
Let me ask a better question. Who's he going to be staying with?
I believe his girlfriend lives at this address, and there may be another. I think she may have a roommate, but I'm sorry, her mother also resides at this address. The girlfriend's mother.
He's staying with his mother and the girlfriend?
That's correct, Judge, and that's usually where he's at anyway. So this isn't like something new. And like I said, Judge, we're okay with even house arrest just until we can get to the exam. And if Your Honor, after hearing the exam, if this complainant actually shows up or participates, we're more than willing to revisit and discuss bond at that time. I'm just really, really concerned for him right now.
What's his present bond?
$100,000 cash, Judge. It's nowhere near affordable for him or his family.
All right, understanding that the purpose of bond is not for punishment and that the defendant has a presumption of innocence. He has no prior criminal record. I'm going to set bond at $100,000 personal with GPS house arrest. As far as I'm concerned, he doesn't have a legitimate job. Doesn't sound like it anyway. So I'm not concerned about that. No contact with any children under the age of 16.
Understood, Judge.
I need an order to that effect.
Your Honor, would that include obviously no contact with the complainant and her family at their house?
Absolutely.
Okay.
That's fine. I'll get that order to you, Judge, forthwith. The other issue is that I did submit a proposed order for discovery as well. And there was a protective order that has been signed by both parties in this case as well.
All right.
Yes, Judge, that would be the same for the other, as the other case. If you can sign those and send me back a signed copy, I can send that all to defense counsel today.
Okay. All right, thank you so much.
Thank you, Judge.
Thank you, Judge.
Who else? Ms. Cassidy.
Good morning,
who is
Judge. I think we have everybody. Isn't that exciting?
That is. Who is this in the Wayne County Jail? What's your name, sir?
Craig Harris III.
That's your client, Ms. Cassidy?
That is my client, and I've got my prosecutor, so we're good to go, Judge.
Okay, we're ready on Harris.
Calling case number 2305-555601 before the state of Michigan versus Craig Harris III. Defendant is charged in count 1, homicide, murder, first degree premeditated. Count 2, weapons, felony, firearm.
Appearances for the record, please.
Good morning, Mike Kleinfeld for the people, P79328.
And good morning, Your Honor. May it please this most honorable court, Nicole Casca, P55470, on behalf of Mr. Harris. Mr. Harris and I are appearing by Zoom video. We do consent to having today's hearing by Zoom video. Mr. Harris, can you please state your full name for the record and that you do consent to having today's hearing by Zoom video?
Good morning, Craig Harris III. I do accept Zoom video.
All right, what's your pleasure, Ms. Caston?
Judge, we do need to set an exam date. I also wanted to order a pretrial services report so that I can address bond. I did talk with the prosecutor in a breakout room, and I had ordered discovery back on February 16th. I haven't received anything yet. So and I know there's a lot because this is a reissue. So Mr. Kleinfeld and I talked, he's going to be working on that and seeing, and getting that to me. So we need to set in a date that is good for the court, but also good for both of us with our trial schedules and give me enough time to read everything and get prepared. And my client does know that we're going to be going outside the 21 days. He does wish for me to have all the discovery and be prepared. Isn't that correct, Mr. Harris?
Yes.
Mr. Kleinfeld, how many witnesses do you have?
I believe it'll be 4. I think it will be, this exam would take one afternoon.
March 21st at 1:30?
I'll be in jury trial, Judge. Could we do the 28th, the following Tuesday?
March 28th at 1:30?
That works, Judge.
Okay, bond will be continued for now. I'll refer to pretrial services for bond recommendation.
Judge, do we want to set a bond hearing date that we can do by Zoom before the 28th?
When we get the report back.
Okay, I will check with your court next week then.
All right, thank you.
I appreciate it, Judge. Thank you. Thank you, Mr. Harris.
Thank you.
Ms. Phelps,
Hello, Judge.
you've been playing peekaboo with me all morning. You ready on Farley?
No, Judge, I'm still waiting for Mr. Farley from the jail. He is in Division 1 though, and I see the chair is empty. So.
Mr. LaMellon.
Good morning, Your Honor. I'm still waiting for, I guess, a domestic violence prosecutor on Jason York, who's on the screen.
We have him here now. We have her here now.
Oh, great. All right, we're ready to proceed.
Okay.
Calling case number 2305-563601. People of the state of Michigan versus Jason York. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, domestic violence, second offense notice. Defendant has a habitual offender, fourth offense notice, mandatory 25-year sentence.
Appearances for the record, please.
Good morning, Your Honor. Sonam Mofsison, on behalf of the people, P83923. I'm stepping in for attorney or APA Drain.
Good morning, Your Honor. Whitney Lemelin, P58914 on behalf of Jason York. He and I are both appearing virtually via Zoom. We waive our rights to stand physically before you. Mr. York, please state your name for the record.
Yeah,
Unmute yourself. You're muted. You need.
Thank you, sir. What's your name?
My name is Jason York.
What's your pleasure, counsel?
Thank you, Judge. After speaking with my client, we need to set this matter for an exam. I also I would like to address bond at the appropriate time.
Court will continue to plead not guilty and set this matter for preliminary examination. How is March 15th at 12 o'clock?
12 o'clock is fine.
That's the bond.
Thank you, Your Honor. My client's current bond is $50,000 cash. Your Honor, my client maintains his utter innocence. He expects that he will be fully exonerated from this matter. However, in looking at his record and in talking with him, there always seems to be one underlying cause which brings him back before you, Your Honor. And my client needs to address some alcohol issues. He would like to see if there was a bond that would be available, which would allow him to get a first available bed at Salvation Army or another treatment facility.
People?
Judge, I'm sorry, I'm just trying to take a look at his prior convictions. I think I don't think that the bond is necessarily set at an inappropriate amount. If it's at 50,000 cash, was there a bond redetermination hearing in this case?
No.
Sure there.
Say that again, Judge.
I'm sure there was.
I mean, one thing is definitely clear. He does have a lot of prior cases involving intoxication. If in fact, I don't know if there's a way to actually monitor whether or not upon his release, if he was to get a lower bond, whether or not he would actually go into a treatment facility, because I do agree with defense counsel. I think a lot of his prior felony and misdemeanor convictions are mostly related to alcohol and then resisting arrest. And so I think the concern would be whether or not the defendant would actually return to a court hearing depending on his sobriety and then his prior history with the police. I don't know if there's any way we can mandate an in-person treatment program as an alternative to being in custody. That would be probably the people's stance if that's possible. Otherwise, I think the bond is set at an appropriate amount given the assaultive charges.
A little more background on my client, Your Honor, once you're off the phone.
Sorry about that, guys.
Thank you, Your Honor. I just wanted to give a little bit more background with my client. He does have a very extensive record. The prosecutor's right. Most of his convictions are based in alcohol. He's been treating at Southwest Solutions. for a long time. He's a constant, he does do treatment there. His counselor is Mike Barrett. He's
So it doesn't sound like
identifying, I'm sorry?
doesn't sound like it's been working.
No, he was in a bus accident, Your Honor. He's been disabled. He's applied for SSI, hasn't received it yet.
Does he have any KPS history?
Not that I know of.
Judge, I can't see his KPS history at this time. I don't know where it would be. I'm just trying to see if they submitted a report for that. I mean, but he does have fleeing and eluding and several resisting arrest convictions.
Yeah, we don't know if those are just pullaways or what, Your Honor. I mean, he's not a violent person.
Did we do a DS in this case yet?
I'm sorry?
Did we do a DSU in this case?
I have not seen one.
Okay, so I'll continue the bond at this time and refer to pretrial services for bond recommendation.
Thank you, Judge. And we'll discuss it on the 15th. Thank you, Your Honor.
Thank you. Mr. Glenn.
Yes, Your Honor.
Here on Davis, right?
Yes.
Hang on just a second. Let me find out who this is in the county jail that's all bandaged up. What's your name, sir? What is it? I don't know who that is.
I think that's Mendez. It's a tether violation.
Oh, a tether violation, Mr. Mendez. Do I have an attorney here for Mr. Mendez? Doesn't look like it. He's here for Davis.
Did they bring Davis yet? The jail call. Said he was getting.
No, I don't see Davis. Are you waiting on your client, Mr. Glenn, or are you going to waive his presence?
I waive his presence. I spoke to him recently about his cases.
Okay. Mr. York, you're all set. You're all set, Mr. York.
Yes, sir. Yes, Your Honor. That.
Calling case number 2305-562801. People of the state of Michigan versus LaShawn Davis. Defendant is charged in counts 1 and 2, assault with a dangerous weapon, counts 3 and 4, weapons, felony firearms, count 5, domestic violence.
This is for the record, please.
Good morning, Your Honor. Sonam of CCN on behalf of the people, P83923.
William Glenn, P 36794, on behalf of Mr. Davis. Mr. Davis is in custody. I've had recent contact with him about his cases, and I'm asking the court to waive his presence for today's hearing.
For the waive the defendant's presence, what's your pleasure?
Your Honor, my client has another preliminary exam scheduled before Your Honor on March the 8th at 10:45. I was wondering, could we put this exam on the same date since everybody's going to be there anyway?
Sure.
Thank you, Your Honor.
March 8th at 10:45. Bond will be continued.
Thank you.
Great, thank you. Judge, I'm being called into another Zoom. I will be right back.
Who said that?
APA Sona did.
So you have something going on more important there than I have going on here?
No, not at all. I just unfortunately was told to log in last minute in your courtroom, and they've been asking for me to log in into the other court, or I've been logged in, they've been waiting for me. So I just need to handle this other matter very quickly. Okay. I was not anticipating to be in front of you, Judge, this morning. Otherwise, I would not have been overbooked, so to speak.
Mr. Woodyard.
Judge, good mornings.
You're here on Inman, right?
Yes, that is correct. Yeah, yes.
What were we waiting on?
We were waiting for a prosecutor, and then candidly, Judge, I'm uncertain if my client has logged on. It appears as though he was granted a personal bond according to the Register of Action. So unless that's changed, he's still out. He and I spoke by phone a couple of days ago, but I don't see him on the call. So I'm just being candid with the court. I'm hoping you don't take any actions based on what I just told you.
What's your name, young lady?
Frida Walker.
Violated my time. Who's supposed to be representing him on these cases?
If
We're just waiting on your attorney, Ms. Walker.
Okay, because I was gonna say, if possible, I don't know if I can represent myself on this case, right, for this.
I wouldn't advise that.
Okay.
So we'll do Inman as soon as the APA gets back, Mr. Woodyard.
Thank you, Judge. I'll be here.
Okay.
Excuse me, Your Honor.
Yes, sir.
We have Mr. Bobby Farley, if you want to do him, and while you're waiting for Mrs. Walker.
Oh, yes, that'll be perfect. Thank you.
No problem.
Street.
March 14th. Mr. Farley, we're just waiting on the prosecutor to come back. We'll be with you in just a moment, okay?
Yes, sir. How you doing? The mom be able to tell the talk. The mom be able to talk. No, it's not. He said calm the judge.
Judge, I just wanted to let you know that I'm back.
Okay, thank you. We are ready on Farley.
Oops, I'm
Ms.
sorry.
Phillips?
I had you muted. Do you mind repeating that?
I thought we were ready on Farley, but it looks like I lost Ms. Phelps again. Mr. Woodyard, you ready on Inman?
I am, sir, yes.
Caller, case number 2305-567101. People of the state of Michigan versus Marcus Inman. Defendant is charged in count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, child abuse, 4th degree. Count 3, domestic violence.
Appearances for the record.
Good morning, Your Honor. Sonam of CCN on behalf of the people, P83923.
And Your Honor, good morning to you and to your wonderful staff. Good morning. Michael Woodyard, P64612. I'm a staff attorney with Neighborhood Defender Service Detroit, and we represent Mr. Marcus Inman. Judge, for purposes of today's probable cause conference, I would ask the court without objection from the prosecutor to waive his presence.
For to waive the defendant's presence, what's your pleasure?
Thank you, Judge. We need to set this matter for a preliminary examination. And also I need to prevail upon the prosecutor to provide video and audio discovery. I have written discovery.
The court will continue the plea of not guilty and set this matter for a preliminary exam. We set it for March 13th at 11:30.
Judge, I actually start a trial on the 13th. Is it any way we could do it later in the week? I think it's going to be a 2-day trial.
March 17th at 12 o'clock.
Perfect.
Bond will be continued.
Judge, thank you so much for your attention. I appreciate it. Have a great day.
Thank you, you as well.
Morning, Your Honor.
Good morning. What can I do for you, Mr. Gerard?
Well, first, please allow me to apologize for making you wait this morning for a DVAPA. I was told by Prosecutor Drain that after yesterday, you were going to be on vacation. Apparently you are not. So here we are. So that was apparently a misunderstanding. So I asked Ms. Movsisian to step in, and as usual, she's right on the ball and stepped up to the plate. So I'll go ahead and excuse her and take it from here.
Thank you.
And Sona, no, thank you. And just give me your notes from today so I know what's set when. I appreciate you. Thank you.
So we don't have a whole lot left, Mr. Gerard. We just have one or two cases left.
Okay. And sir, you'll be on the bench the rest of the week?
No, today is my last.
Oh, today is, okay. Well, my information was a day off. So there will be no cases scheduled on your docket that we need to cover the rest of the week.
No exams, but there will be probable cause conferences.
Okay.
So we're waiting on Ms. Phelps to come back to do Farley.
Okay.
Excuse me, sir.
Yes.
Will I be able to talk to the attorney before we start?
Before we start?
Yes.
That's a very
Just
possibility.
30 seconds. Thank you.
Okay.
Excuse me, Deb. Yes, sir. I'm still waiting. You have to use the bathroom.
Thought you was about to start.
I think we went on an attorney.
Concerning this matter, using the contact. Yeah.
Excuse me, officer. That's him?
Yeah.
Okay. Thank you.
Oh, yeah. You know,
This is where we're using the attorney.
Ms. Tiefo. You here on?
Morning, Judge.
You here on Jeremiah Mendez?
Yes, I understand there's a tether violation. I was waiting in Judge Giles. Apparently there's a tether violation there. I wasn't sure if it was the same one.
I think it is. I think this is the one he sent over to me.
Okay, either way.
Sure.
Calling case number 2206013001. People of the state of Michigan versus Jeremiah Mendez. Defendant is charged in count one, assault, resisting, obstructing. Count two, malicious destruction of building, 200 to 1,000. Count three, domestic violence.
Appearances for the record, please.
Bring Your Honor, Tricia Gerard, P43834 on behalf of the people.
Rebecca Tiapo, P62311 on behalf of Mr. Mendez, who appears to be appearing on Zoom from the Wayne County Jail.
Mr. Mendez, we couldn't hear you earlier. Let's see if we can hear you now. Tell me your name.
Jeremiah Jesus Mendez, Your Honor.
All right, great. So Mr. Mendez is before the court on a tether violation. He was placed on the tether back on February 14th, and allegedly he was picked up on a felonious assault on February 20th.
Your Honor, at this time, the people would respectfully request that the defendant's bond be revoked and he be remanded.
Ms. Tiefo?
Your Honor, so I believe the new case before Judge Giles is the case in question. I've not had an opportunity to take a look at the information on that. I would ask the court to consider permitting him to stay on tether. Obviously, he's not going to go anywhere without the court being advised. And he has been before the court on several occasions. I have no reason to think he's not going to appear in the future.
Well, it's not necessarily his appearance was the concern. The concern is whether or not he poses a threat to the community in that he's picking up cases while on tether to me. I have an issue. I have an issue with that. So, Mr. Menendez, what happened to you? Why are you all bandaged up?
I'm having seizures inside. I have seizures. I have epilepsy, and I'm not getting on my right medications. So I have a broken arm due to I got it ran over, and I dislocated my collarbone, from the seizures and falling.
When did all that?
Inside Wayne County Jail.
You say you got run over.
No, my arm got ran over downstairs in intake. I had a seizure and my arm was in the middle of the door. When they tried to come in to help me, it got smushed.
Interesting. Okay. Well, like I said, I have an issue with you picking up another case while on tether to me. For that reason, the court is going to revoke your bond. I am going to remand you because I believe you are a threat to the community. All right, thank you.
Thank you, Judge.
Thank you, Judge.
Comes Ms. Phelps now. Ms. Phelps,
Good morning.
hello again.
Hello again.
I'm gonna get some handcuffs just for you.
What's that?
I'm gonna get some handcuffs just for you.
Okay,
Your client wants to speak to you before we go on the record.
great. Thank you, Judge.
Go ahead and join the breakout room. Ms. James?
Hello.
Ms. James? What can I do for you, Ms. James?
Judge, I thought I saw something that told me to log in.
Ms. Wilmore,
Oh, okay, so, yes, I think you have a tether violator. Oh, it's a Boston?
Right, Judge, he's in the Wayne County Jail.
I'm sorry, it's not a tether violation, it's a competency report.
Okay. I'm out of town, so I don't have a copy of the report.
They make a finding that he's not competent to stand trial.
Okay.
So I just need the APA on that. I'll be with you in just a minute, Ms. James.
Okay, no problem.
All right, Ms. Phelps, are you ready? Are you ready, Ms. Phelps? I can't hear you.
She said.
Now I can. Okay, we're ready on fire.
calling case number 2305-56501. People of the state of Michigan versus Bobby Farley III. Defendant is charged in count 1, assault with a dangerous weapon, count 2, charges for 3, count 3, domestic violence, second offense notice.
Good morning, Your Honor. Tricia Gerard on behalf of the people.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps. P83355 appearing on behalf of Mr. Farley, who's also present via Zoom. Mr. Farley, can you please state your name for the record?
Bobby Lewis Farley III, Your Honor.
All right, what's your pleasure, Ms. Phelps?
Your Honor, it looks like we're just missing digital discovery on this case, but otherwise I am ready to set this for a preliminary exam.
All right, the court will continue to plead not guilty and set this matter for a preliminary exam. Set it for. How is March 13th at 10:30?
Your Honor, I am scheduled to start a jury trial that day. That should go through the 15th. If you have any availability next week, I have a lot more space.
I don't have anything available next week.
I could do
think your trial will last how long?
It should be about 3 days, Judge.
March 17th?
Yes, what time would be good on the 17th?
Let's do 1:30.
Okay, great.
I'll make sure you get discovery, Ms. Phelps.
Thank you, Mr. R. Mr. Farley, we're all set, so I'll see you tonight, okay?
Okay, thank you, Your Honor.
Continue, thank you.
And Judge, we said 1:30, right?
Yes.
Okay, thank you. Have a good day.
Okay, thank you.
So are we done with Ms. Gerard?
Yeah.
Okay, Ms.
Your Honor.
Gerard,
Oh, I'm sorry, sir.
go ahead.
I think that Ms. James' case belongs to APA Wilmeth, so I texted her. I can hang around until she zooms in if you wish.
That's television.
Okay. What's your name again?
Frida Walker.
All right, another tether violator, Ms. Walker. Who's her attorney?
Mr. Kenneth. Mr. Kenneth.
Mr. King.
Yeah. I emailed them, no response. I called. Set it up until tomorrow.
Okay, we're gonna put your case over till tomorrow. We're trying to get in contact with your attorney.
Can I Can I represent myself, please?
Want to represent yourself?
Yes, Judge, may I please represent myself? This was a simple mistake. May I please represent myself?
Okay.
Calling. Case number 2305564901. People of the state of Michigan versus Frida Walker. Defendant is charged in count 1, home invasion, 3rd degree. Count 2, malicious destruction of building, 200 to 1,000. Count 3, domestic violence.
Appearances for the record, please.
Commissioner Gerard, on behalf of the people, Your Honor.
Tell me your name, Ms. Walker.
My name is Frida Walker.
Okay, Ms. Walker is here on a tether violation. She was placed on a tether on on February 24th. And on February 27th, she had some indirect contact with the complaining witness using a text message. So you sent a text message to the complaining witness, Ms. Walker?
Is this a yes or, is this a yes or no, or may I say something?
Go ahead.
I actually called the police as well before that message was sent because he sent me a message. We have a 1-year-old daughter involved. That's why I was trying to see if we can come and make different arrangements, because I called the police because he called and said he was coming to kill me because of my daughter. We have a 1-year-old. So then I text his mom, and in the message you can see I told his mom to tell her son to leave me alone and let's just let this court play out first. So Judge, I'm asking if I can please if I can go to family court so we can set up some visitation. I don't communicate with them. I don't talk to them about nothing. I just told her to tell her son to leave me and my daughter alone. That's it, Judge. I called the police myself and told them he called me and threatened me and told me he was on his way to my house. That's why I responded, and I'm not saying that it's okay, Judge. I sincerely apologize, but I'm letting you know I got messages. He tried to come to my house Friday and everything. I promise you he did. So if I can please get out, Judge, so I can please take care of this court in the family court, so this won't happen again. That's the only thing it's just this one. We have a 1-year-old daughter, Judge.
Ms. Gerard?
Your Honor, in the addition to the tether, was there any kind of monetary bond or was it a personal?
It was personal.
I believe it was personal bond.
Okay. Your Honor, based on that explanation, I would not have any objection to the defendant's bond being reinstated. And I know the court will clearly explain to her what no contact means. And it's very apparent that Ms. Walker needs to consult with an attorney as soon as possible.
All right. It does appear as though there's a lot of truth to Ms. Walker's statement in that the incident report indicates that there was indirect contact with the defendant and the complainant. And be consistent to her explanation as to calling or texting the complainant's mother and telling the complainant's mother to tell the complainant to leave her alone. We don't want you to have any contact whatsoever, ma'am. You understand that? No contact means exactly that. No contact, okay?
What about my daughter? If he have my daughter when I get out, can I just get my daughter?
I don't want you to have any contact whatsoever. You have to go through legal procedures in doing so, okay? So you are going to have to file your petitions in family court. I'm not going to give you any legal advice, but you know what you have to do.
Judge, I was on house arrest. I promise I'm trying to do it. Can I please I just want to, I don't bother him. I don't talk to him.
Well, that's what I'm trying to ensure. I don't want you to bother him. I don't want you to talk to him or anyone connected to him, okay?
Yes,
So
sir.
I am going to reinstate your bond.
So I'm gonna get out on a tether.
Yes, ma'am. No contact with the complaining witness, okay?
Do it have to be house arrest? Cause if he have my daughter, I won't want to go to court again. If I just want my daughter.
Court is an exception. You can go to court even if you're on house arrest,
Okay,
all right?
okay,
Thank you.
thank you.
Your Honor, Ms. Wilmoth is in a jury trial here at Frank Murphy, so I am happy to stand in for her on Ms. James's matter.
I appreciate that so much.
For sure.
Calling case number 2206-005701, for the state of Michigan versus Ibrahim Olatunbasa. Defendant is charged in counts 1, 2, and 3, criminal sexual conduct, first degree.
Appearances for the record, please.
Patricia Gerard, on behalf of the people, Your Honor, standing in for APA Aaron Wilmoth.
And good morning, Your Honor, Nicole James, on behalf of the defendant.
All right, so the court is in receipt of a report from the forensic center that finds that the defendant is incompetent to stand trial at this time, but is likely to attain competence if provided a course of treatment within the time limit established by statute. Are you willing to stipulate to that report, Ms. James?
Yes, Your Honor.
And Ms. Gerard, on behalf of the APA assigned to this case?
We stipulate, Your Honor, to the report, and we respectfully request that the defendant be referred to the Forensic Center for treatment in order to restore him to competency.
So ordered. The court makes a finding that the defendant is incompetent to stand trial at this time, but will refer him for treatment and will set a review date for May 30th, 2023 at 8:30 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Have a good one, everyone.
Thank you.
Mr. Gerard, I really do appreciate you. Thank you so much, okay?
No problem, Judge. One question. If I run the docket under your name, any PCCs assigned to you will pop up for me?
Yes, it should.
Okay, and is there a specific judge that'll be covering your docket?
I believe Chief Judge McConaughey is going to cover most of the days.
Okay.
What I'm going to do is I'm going to prearrange dates to adjourn the probable cause conference. No exams will be set until I get back.
Okay, very good, sir. And you'll be back on which date?
March 8th.
Very good. Have a wonderful vacation, sir. Be safe. Thank you.
Appreciate it. So I think that's it.
What time is your party?
12:30.
I mean, okay. 12:30, guys.
I'm gonna plan my strategy here in just a moment.
Okay.
What's going on, lady? Thank you much. How you doing today?
Good. Okay.
Huh?
Y'all good?
Oh, yeah. How about you?
I'm good next door. Hurricane, how you feeling? I'm good. Thank you.
So what you think? Should I get some pizza too? Got subs, chicken, macaroni. So, you know, some people may not want to do that and be partial to pizza. I can pick up a couple.
No more than two. Right.
What's all that?
Oh, that's supplies. Oh, just like office.
Oh, okay.
And
on strategy.
All right, text me or I'll come up in a minute.
Okay.
Mark you go on.
All right.
One line for you. Or meet your mom and dad.
Maybe I don't have to do that.
Okay. You know, do you know what time they're coming?
I think 12:30.
Got it at the judge's door?
Yes.
Okay, we got a card right here. Oh, we have to do that. I was gonna text you yesterday.
So how do you just set this up? Are we gonna just leave the desk like that?
Yeah. So share stuff.
Okay, so. Okay. I'm gonna have to come all the way around to get the remote.
No. Wait. Oh. Where is it? This one? And, yeah, see, oh,